Yes, Ms. Milford.
Thank you, my lord. So I got to the claimant's fourth ground of appeal, the Jaffrey point, I think.
Yes.
And we say that the answer to that point is that this is a case where the nature of the error made by the tribunal meant that only one answer was possible. The claimants put forward a case, and avowedly so, which asked the tribunal to apply an inappropriate rule for comparison. And that's what the tribunal did. And we say that was an error of law, which inevitably meant that the claimants have failed to make good their case on disproportionate impact. And on that basis, on the correct legal approach as applied by Mrs. Justice Eadie, the case was bound to fail. And what you are now invited to do is to remit the case back to the tribunal, presumably for the respondent to produce further evidence on other contracts and for that to be argued about, when the claimants never took steps to get it the first time round. And we say that would be inappropriate and unfair. And it's also an approach that's contrary to Jaffrey itself. And if perhaps I can just ask my lords to turn up Jaffrey at tab 19, at page 313. And there, explaining dismissal of appeal, at paragraph 40, Lord Justice Law says, don't consider in all circumstances the fact that...
Just a moment.
I'm so sorry, my lord. So, page 313.
Paragraph 40.
Paragraph 40, and the point is there that the basis for refusing the invitation for remittal is to say the reality is that a remittal to the Employment Tribunal would be an invitation not to reach a fresh decision on a correct understanding of the law after an earlier error, but to have the case substantially relitigated. And that's what we say, in effect, is being asked for here. So that's our answer to the Jaffrey point. And my lord, that brings me on to the points in the respondent's notice.
Yes.
And just by way of introduction, we say that on the tribunal's factual findings, the claimants were carrying out manual work. The Royal Parks' own employees were engaged in administrative and professional work, so work of a totally different kind. The Royal Parks' employees were paid above the London living wage because that was the effect of civil service pay rates. And the bodies setting pay were different. The Royal Parks for its own employees, Vinci for the claimants. And the claimants were paid what their own employer considered to be the appropriate market rate. And in those circumstances, my lords, we say that a finding that the Royal Parks has discriminated against the claimants insofar as they're not paid the London living wage is a surprising one. And it is a useful sense check, if no more than that, to say what would happen if you're looking at the lex specialis for equal pay, and there'd be a whole range of likely defences to an equal pay claim, including no common employment, no single source, market rate material factor, and claimants and comparators not doing work of equal value.
I'm very sorry, could I just situate this argument within the respondent's notice?
Yes.
Which I think begins at page 26.
Yes. So this is really by way of introduction, my lord, to all three of the points that are made in the respondent's notice, but I'm going to deal with point 2 first, because that's the way in which it's done in the skeleton. So I'm going to deal with different circumstances, which is page 27, subparagraph 2.
Position, is this?
Yeah.
So this is
That's
your
what I'm going to start with.
Respondent's notice 2, comparable position.
Yes, yes.
I don't really understand what the fact that somebody in the office is doing office work and somebody is cleaning and they're doing different sorts of work. What's that got to do with it?
Likely to be a very different market rate, market value.
But that takes us to the question of what has market value got to do with this at all? It's a safety net.
Just first, just before we get on to that, so different work you're not actually relying on. There was flavour that you were relying on it, on a sort of saying that it was a factor in its own right. But you're not relying on that. You're relying on it only, as I understood your answer to my lord, on the basis that it is relevant to or feeds into the point about different rates.
All of this feeds into the point about different rates, my lord. I mean, there's different work
market
is one
rates, I should have
aspect of it.
said.
Civil service pay and conditions is another.
Well, civil service pay and conditions is just another way of saying different rates, isn't it? Well, but I think I don't want to have the argument with you now. I just want to clarify. You are not saying that the fact that one is doing manual work and the other is doing office work is relevant as such.
No.
Right. Thank you.
No.
Right. Well, that's helpful. In that case, why is different pay relevant as such? That's just begging.
Well, different market rate, my lord, is relevant as such.
They're not asking for the same pay.
No.
They don't want to be paid the same. They want to have the same basic floor that they never fall below, or they won't be able to pay the groceries.
Well, I think two points on that, my lord. I mean, the first is that comes back to the issue of whether, how the tribunal applied the comparison, whether it should have taken into account circumstances other than pure need. And I'll come on to that in due course.
That's a different point.
Which is a different point. But insofar as one's saying a different rate, then it is relevant in my submission, my lord. I mean, it's relevant in two ways. I mean, first of all, if the rate is actually above the London living wage in the first place, then why should they be in the pool at all?
But you adopted a practice. I mean, these understand these points, but you had a policy.
Yeah.
It's your policy that your people don't get under the London living wage. I mean, why is this relevant at all?
Well, my lord, that's what I'm going to develop, and the point is that when you are, both for the purposes of comparison within Section 23 of the Equality Act, and for the purposes of deciding what is the appropriate pool, and those might be said to be twin sides of the same coin, you've got to look at people who are who are adversely or positively affected by the PCP. And if someone is getting more than the London living wage for reasons that are totally unrelated, which is to say, civil service pay rates require it or the market requires it, then they are not positively or negatively affected by the guarantee that you've given.
Can we
So
just
not
spell
within the
this
pool.
out, though? I do understand the argument that the London living wage can't be said to have been being applied to people who earn twice as much as it anyway. Maybe right, it may be wrong. And that is clearly part of your argument. But is that the whole of your argument, that it's not applied to people who would not otherwise get more than the London living wage?
My argument is that it's not applied to people who would otherwise get London living wage, and also that people who would otherwise get London living wage are not in comparable circumstances for the purposes of Section 23. But I appreciate, as I just said to my lord, that those might be said to be twin sides of the same coin. but one gets to the same result either way, whether you do it through the prism of section 19 and saying, is it applied, or through the prism of section 23 and saying, are the people in the pool in a comparable position?
I think the second one, the not material, it's almost what you look at. Do you look at the needs of each individual, and they will broadly be the same, whatever they're doing, whoever employs them. If you live in London, the tube is expensive and Tesco's is double the price. And that's that. It's only if you decide to make material things that the tribunal and the EAT said were things that they didn't have to consider, that you switch from being material then. So it's not sleight of hand, I'm not suggesting that.
Yes.
But it's really not looking at the core issue, I think.
Yes, on section 23,
Yes.
I
Section
entirely
23
agree with my lord. That is the point, and I say that actually, if you look at section 23 properly, those sort of differences are material, and it's not sufficient just to say they all have an equal need. But I'm going to
But that's
develop
because
that.
you criticise
Well,
the equal need point.
Perhaps we'll let you develop your points, and then if we still haven't understood them, we'll come back to you. Yeah.
So let me start, my lord, if I may, with the comparison of circumstances point. That's paragraphs 24 to 39 of my skeleton. And we say, as I've just foreshadowed, tribunal erred in law in concluding there was no material difference between the circumstances of the claimants and those of the Royal Parks' own employees for the purposes of section 23. But that's also a pool.
So sorry, when you just started, I was just going to put in the cross-reference to your skeleton, but I didn't.
So it's Paris, the 24 to 39, pages 49 to 53.
24 to 39 is Paris, I think. Yep. Okay. Thank you. Sorry, and then just give the proposition again.
Yes. And we say that the tribunal erred in law in concluding that there was no material difference between the circumstances of the claimants and the circumstances of the Royal Parks' own employees for the purposes of section 23. So that's the proposition. But I also I make that also as a pool argument, and I'll develop that in due course. What I would start with is just the principles that we say apply to section 23. The section says on a comparison of cases, there must be no material difference between the circumstances relating to each case. And my lord will appreciate it's slightly more unusual to come across an application of section 23 in the context of indirect rather than direct discrimination. But it nevertheless applies and expressly applies to indirect discrimination as well.
I do myself have always thought that was a bit odd, but there's high authority that it does, isn't there? Was it Naeem? Was it decided Naeem or? Where have you authority?
Well, there's actually the clearest statement of it is the case of Capita against Ali.
Okay.
Which I'll just take you to now. It's tab 25. So that, just to set the scene, I mean, this is these are claims about whether it's unlawful discrimination for men to be paid less on shared parental leave than birth mothers are paid on statutory maternity leave. And Ali was a direct discrimination claim. Hextall was an indirect sex discrimination claim. And in the reasoning in Ali, the court explained why men and women were not in comparable circumstances as far as that is concerned. And the same point was applied across to indirect discrimination in Hextall. And one sees that at page 459. And I've just asked you to read paragraph 120 on that page.
Yeah, thank you.
And a couple of other cases on this issue that I just want to pick up briefly. And the first is Shamoon at tab 10, which my lords will be very familiar with. I mean, that's the case about discrimination as removal of the claimant from a post of counselling officer following complaints about the way she carried out her role, and she seeks to compare herself to men who have not had complaints made about them. And all that I just wanted to pick up from this is the passage in Lord Hope's speech at paragraph 48, page 122. Where he indicates, and it's towards the bottom, that the phrase "the relevant circumstances" and the comparison of the relevant circumstances directs attention to all the circumstances which are relevant to the way in which.
Sorry, where are you reading from?
I'm so sorry,
48.
Yes, 48, and it's just below B.
Oh, on the following page. I'm
Yes,
so sorry.
on the following
Yes, I have
page.
it.
Sorry.
Yep.
Yeah. The circumstances. So this is a comparison of the position for victimisation and discrimination, which for present purposes is just background. But the relevant bit is the end of that paragraph, which is the phrase directs attention to all the circumstances which are relevant to the way in which the woman has been treated. And that sentence we say is important because the point there is that the circumstances are not just a question of what claimants may need, but what are the circumstances which help explain why the employer has treated them in a particular way. So one can't sort of short circuit that analysis just by saying, I'll come on to this in due course, just by saying, well, everyone has an equal need for the London living wage. One needs to look at why has the employer treated them in a particular way. And in the case of a complaint about pay, such circumstances can almost always will generally include the fact that different work of a completely different value is being done.
Isn't that just the approach which I took in this court in Naeem and was found to be heretical? You don't, in a case of indirect discrimination, you don't ask why the situation has arisen. It simply focus on the fact that two people are being treated differently in the same circumstances.
Will you
do relevant to the way in which the person has been treated? I don't think Lord Hope had in mind quite the point that you're now foisting on.
I'm not seeking to suggest, my lord, that one needs to say why is a PCP indirectly discriminatory. I mean, that is obviously that is the point that Lady Hale says doesn't need to be decided. But I am saying that one needs to look at, as indeed Lord Hope says, you need to look at the circumstances which are relevant to the employer's treatment.
So
and that's
decide to pay the London living wage because there's something about office workers which cries out for it, but toilet cleaners don't need the London living wage. They don't seem to be matters that good. I understand pay. If you're going to pay somebody £100 rather than £200, you might ask, what are they doing and so on. But this isn't about that. This is they've decided that their workers should get a floor, but they think other workers shouldn't get a floor. So I'm not sure whether they're sitting on the floor or cleaning the floor makes any difference.
No, and that, I mean, it may... difference in the work being done, I'm not in itself, I'm not saying is relevant. I am saying that market value is relevant.
Well, the attractiveness of your submission might lead us to overlook what seems to me to be the problems, the real unattractiveness of this submission. It would seem to be inherently discriminatory to say that because people who don't get their hands dirty get paid more, therefore they can't be compared with people who do get their hands dirty. I mean, it surely would lead to a situation, I give you this opportunity to reassure me, but lead to a situation where the discrimination law would be completely ineffective in this area, that employers like yourself simply outsource everything and say, we've kept the higher paid, and they're not comparable.
I think probably, perhaps what I need to separate out a couple of different points. I mean, one is a slightly different point, which is that if you're getting above the London living wage anyway, you're not appropriately included within the pool.
Yes, to myself, I regard that as a different point. I know you said there were two sides of the same coin. I'm not sure they are. Or perhaps that wasn't what you said was two sides of the same coin. Anyway, that particular point, I think, is just different from the one I understand you to be addressing now.
In which case, I've probably not made myself entirely clear, because what I'm trying to say is that if the market value of your job is going to be above the London living wage anyway,
but
why are you included within it?
I mean, people who get paid a lot need toilets. I mean, everybody's in the organisation for a certain amount of basic necessity. There's a necessity in the office space. There's a necessity in being able to feed and clothe yourself. I'm just wondering whether the Royal Parks have thought through what seems to me to be the profound consequences of a submission of this sort.
I don't think. I mean, it may be that I'm just being unclear, my lord. I mean, I'm not trying to say that just because people did work of a different kind, they would not be.
Because they happen to get paid more.
I'm saying because they happen to get paid more than the floor.
Right, so let me ask my supplemental question. All right, let's suppose there was anything at all in that argument. Where do you draw the line? Who are the comparators, or is the office empty by the time you come to find a comparator?
Well, in this case, my lord, on the factual findings, the office is empty. The office is empty.
Right. So you're effectively bomb-proof against discrimination claims.
Well, my lord, and that comes back to the point I was making at the start, which is it's not surprising, because an equal pay claim here would be doomed to failure.
It's not an equal pay.
I appreciate that, my lord.
But
if everyone to whom you are giving the quote unquote benefit of a floor is above the floor anyway for unrelated reasons, why are they within the pool? They're not people who are affected positively or negatively.
You said they were in the pool. It was litigated below. I mean, I see that this arose in the EAT. Can you just remind us, was this a point in the ET?
The point was made in the ET, and I was going to take my lord to it, that the claimants and the comparators were not in comparable circumstances. And one of the, two of the reasons for that were paid civil service terms and conditions and market rate. And I say that's right, because they all mean that these people are above the relevant floor being applied for unrelated reasons.
Isn't civil service terms and conditions a bit of a red herring? Civil service terms and conditions might be below the London living wage. Factually, you'll tell me they aren't, and that doesn't surprise me. But that the important thing is that the rates which they are being paid are above the London living wage.
Yes.
There's nothing magic about civil service terms.
There's nothing magic about that. No.
But can I just explore one possibility, which is, well, two points, but one leads into the other. First point is Mr. Khan's point that, in fact, Royal Parks there is a risk that some people in Royal Parks would fall below living wage, and they have a policy of always increasing the rates at any rate. It's not quite clear from the language, but from the language seen, of the people at the lower end by at least CPI, because if they didn't, given that London living wage is always increased by CPI, after a year or two they would fall below, and there is evidence that that is the position. So to say the London living wage isn't relevant to these people because they're always paid more than it, they're only paid more than it because you have a policy for the lowest paid ones of making sure that they're always above it. There's no obligation to raise wages by CPI otherwise, and some employers don't in hard times.
No, and I've obviously seen the extract from from
Perhaps you're going to come to it
from the
later.
submissions. I'm going to come to that because I don't think it says quite what Mr.
all
Khan
right.
indicates, and indeed, if it did, it would be contrary to the factual findings of the
But
tribunal.
if you want to park that for a moment,
Yes.
but then that leads on though to this point. You could easily have a situation, though subject to the point we parked, in this case we don't, where out of the 160 direct employees, 20 or 30 were maybe doing low-grade secretarial jobs, as far as there are such things anymore, and are only kept above water by a conscious policy to increase their wages to the London living wage.
Yes.
And they therefore will be in the pool because they're getting the benefit of it.
Yes.
But the people higher up wouldn't. So you'd actually have to decide, you'd have to look at your pool of 160 people and make a decision out of those 160, how many actually get the benefit of the London living wage policy, and only those are going to the pool. And that might or might not produce a different outcome in terms of ethnic mix.
Yeah.
But I think it's the logic of your position that even though you say it's not the facts here, that's how it would have to work.
It is the logic of my position, my lord. Yes.
That makes it very messy.
And I appreciate that, but I nevertheless say that that is what the law requires, because the other people who get more anyway are not people who are positively or negatively affected by the PCP at issue. But as my lord says, not these facts. But
Yeah,
yes.
okay. But but in a sense, it doesn't matter they're not these facts because it informs the principle.
Yes.
You have got to say, and I think do say, that we're slipping over into the other point, that the London living wage is applied to the whole of 160 people. It's true that in some of them it doesn't factually make a difference, but it is the policy, they all get the benefit of it. That is your position, isn't it, I think?
Yes, but if subject to the point that we've been talking about, that if in fact they're already getting.
Sorry, yes, I think I put it badly,
Yes.
but yes. Okay, thank you.
My lord, I wonder if I could turn to the tribunal. Perhaps the right place to start is just with the tribunal's analysis, and then I'll deal with the points that we make. And the tribunal's reasoning is page 122, paragraph 70, tab 9. And that paragraph puts forward two alternative comparisons. The first analysis is to say that there's no material difference between the claimants and the Royal Parks' own employees, because some of the BME persons in the pool were employed by the Royal Parks and others worked on the Vinci contract, and the same applied to non-BME persons in the pool. So as far as that is concerned, we say that comparison doesn't involve any comparison of circumstances at all. It just points out that Vinci contract workers are both white and BME, and the respondent's own employees are both white and BME, and that is irrelevant. And I don't understand that to be that and bit of the analysis to be defended. It's the second comparison that is defended here, and the second comparison starts about sort of 8 lines down, or 10 lines down. It's if we are wrong. So that we did not have to consider, for the purposes of sections 19.2b and 23.1, whether there was any material difference between the circumstances of those employed by the respondent and those employed by Vinci. If we are wrong and such a comparison had to be made, we would have concluded that for the purposes of determining whether LLW should be paid as a minimum wage to the two groups, there was no material difference between them. LLW is the amount that the Living Wage Foundation considers the minimum that a person working in London needs to meet his or her basic living costs. That figure applies to all persons working in London, regardless of the identity of the worker's employer or the nature of work that he or she does. And we do say that that is a legal error, because it means that the tribunal didn't consider whether their different treatment was explained by circumstances that were material to the way in which they're treated by the employer. It implies what is in effect a social policy test, which on the tribunal's analysis will always apply to any worker in London. And if that was the correct approach, in effect, section 23 would be a dead letter in any indirect discrimination case involving workers from London, because the assumption would always be that each group had an equal need for the London living wage.
Why is that
And that has the difficulty that it just sort of short circuits all the reasons why put forward by the respondent, why its own employees might not appropriately be in the pool, including the fact that they get paid civil service terms and market rates, which are above the London living wage anyway.
So far, I've only really detected one material difference, which I do actually think is a difficult point, but you're referring to civil service rates and market rates and so forth. The only point that the moment I see where it really bites is that some of your direct employees would not otherwise would not get the benefit of the London living wage. None of them would, you say? Yeah. Even if a few of them would, only those ones go into the pool. That's your only material
My Lord, I think that is yes. I entirely take the point that my Lord is putting to me, and I think that is fair. So although I put it in more than one way, actually, in the end, it probably doesn't matter what the particular reason is why they're getting paid more than the London.
And I think at this point, I probably do think you're right. You can say it means you're not applying the PCP to them because it has no relevance to their circumstances, or that they're not relevant people to put into the pool because we're effectively the same point. Yes, I see. Okay.
Yes.
So how would you draft the? I mean, if they hadn't gone wrong at 70, what's the third way of putting it that you contend for?
Well, what I contend is that the differences which were argued for by the respondent, and I'll come to, and there are differences set out in the skeleton argument, which I'll come to, that the proper thing would have been to address those and say, do any of them make any difference to the conclusion that we've reached? Yes, actually, the civil service terms and market forces ones do, because they mean that everyone was getting paid more than the London living wage anyway. But that bit of the analysis was not conducted. But what did happen is that one had factual findings from the tribunal that indicated that the analysis did need to be conducted, because you've got them at paragraph 31 of the reasons, page 110. The employees who transferred from the civil service are paid according to the rates of pay determined for their grades by the civil service. There is a range of pay for each grade. All the rates of pay are over the London living wage. The rates of pay for staff recruited by the respondent based on the market rate at the time, but are never less than the rates of pay paid for that particular role under the civil service rates of pay. So, I mean, I just stop there and I say, well, that in itself, factual finding.
So where were you reading from? That's number 31.
So because somebody is at the relevant time paid over the London living wage, or even at the London living wage, maybe it matters?
No, it would only matter if they needed to be bumped up, my lord. That's right.
Right. Okay. So you would have to carry out a study as to which of your employees the London living wage mattered to.
Well, here no study was required, my lord, because the point is that it didn't matter to any of them. That's the factual findings of the tribunal.
Well, the fact one's paid over the London living wage doesn't mean it doesn't matter to you.
Well, it means you're not affected by a provision, criterion, or practice that you should be
You've got
paid.
a guarantee that you're not going to be paid less than London living wage because you can plan your life on that basis.
Well, my lord, you'll plan your life on the basis of the salary you get given. But I do say that if one's looking at the entirety of the relevant period here, so the relevant period is 2014 to 2019, and after 2019 one can put out of account because from that time on the claimants are also paid the London living wage. If in the whole of that time there is actually no point at which anyone needs to be bumped up in order to meet the London living wage, and it's not actually been applied to them over that relevant
It
time.
depends on what it is.
Yes, exactly.
I mean, I promise to care for you. You look tremendously healthy. I'll never be called upon to do so. But what I've done is I've applied a criterion that says I will care for you if you become ill. Mr. Carr, I might say, well, I know you are ill, but I'm not going to look after you. And that is the difference. The factual circumstances don't require you to bank the guarantee, but the guarantee is there. And the practice is I will make sure that my people don't fall below the London living wage. Fortunately, at the moment, unless inflation goes haywire again, I won't be called upon to do any more than I'm doing anyway. But nonetheless, I'm guaranteeing it, and it is the guarantee. But I'm not doing that for the other people, and they poor devils need it, according to the tribunal.
Well, my lord, I might just show, if I may, I would just take you to an authority called Pike that indicates that that sort of contingent analysis that you might need it in future is not the one that's been applied when one's looking at, you know, are you...
What's the authority?
So it's Pike, which is tab 17. So that's a claim about equality of access to the teachers' pension scheme, where what's said is that the rules of the scheme were indirectly discriminatory against women. And there was a rule applied within the scheme that you couldn't join it if you retired and returned to work part-time. So it's a part-time versus full-time issue. If you retired and returned to work full-time, you could rejoin. And the question was whether the correct pool for testing that rule was all teachers, in which case there was no significant disparate impact because vast majority are members of teachers' pension scheme, or just teachers who've retired and returned to work, in which case many more men than women were advantaged because they retired and returned to work full-time rather than part-time. And the Court of Appeal said that the correct pool wasn't all teachers, because a teacher who hadn't retired and returned to work was not affected by a rule which excluded part-time returnees. So it was only returnees themselves who were affected by the rule. And if one picks up the reasoning at paragraph 8, Lord Justice Maurice Kay cites the critical part of the reasoning in the Employment Appeal Tribunal, which applies Rutherford in the case of the House of Lords. Those who are in the teachers' pension schemes is not retired are uninterested in the post-retirement rules, ... to describe them as an advantaged group for the purposes of juxtaposition against the disadvantaged group of part-time returners is an abuse of the language. These people had no advantage out of the post-retirement rule favouring full-timers. It simply didn't apply to them. They could only distort the view of the pool. For the purposes of this appeal seems to be the only logical pool. This is, I've described it, returners. And that ends up being the approach applied by the Court of Appeal. And that emerges from a discussion, and what's the discussion first deals with is a case called Rutherford in the House of Lords, and Lord Justice Maurice Kay says that the ratio of Rutherford is effectively Baroness Hales, which one sees starting at paragraph 15. Perhaps we can just read that. And then at 18, the entire teaching profession was an inappropriate pool because what was being done is to bring into the equation people who've no interest in the advantage or disadvantage in question. And the smaller pool was the right one. And that reasoning, my lords, does have significant resonance here.
Can I just check one thing, Mr. When they talk about interest, do they mean somebody who can benefit from the rule because you had to be retired and therefore had to be over 65, and people who weren't legally in that position couldn't benefit? So interest isn't being used loosely, it's legal entitlement. Or legal circumstances which would trigger a benefit.
I think that's, yes, my lord. And the fact that in the future, someone who's not retired might have wanted to retire and return to work full or part-time was not sufficient. That was not a basis for widening the pool to include all teachers. And I do say that if one applies that approach here, it leads to the exclusion from the pool of people who are paid above the London living wage for totally unrelated reasons. And, you know, the fact that in the future their pay might putatively fall beneath the LLW and need to be raised to it does not, in my submission, make a difference if in the entirety of the relevant period, no one has ever been in that position.
Isn't the true comparator for Pike one of the alternative pools that you put forward, namely all Vinci employees, wheresoever they were? Those people are the Pike people, aren't they? Not the people in your office who happen not to be near the threshold.
For the purposes of the PCP, my lord, which is your employees, you know.
Well, I know, but I'm
Then
you understand the point that I'm making, namely, people who are not concerned with this issue would be other Vinci workers not working for Parks.
Well, no, my lord, I think it would actually be, my analogy with respect, I think, is the right one, because the employees who get paid over the London living wage anyway are, in my submission, in an analogous set of circumstances to pre-retirement teachers. In other words, the fact that there might be some sort of guarantee or rule which would apply to them if hypothetically their pay ever did fall below the relevant threshold.
You did answer this, but I didn't catch it, I'm afraid. But where do you draw the line?
You draw the line at people who, at any point in the whole of the relevant period, might have needed their pay to be bumped up in order that the London living wage is paid to
might
them.
is vague. Would
Have needed.
You mean they're already above the living wage? Are they? I mean, the starting point is what you assume that there's nobody that's below it, but factually there isn't. You start with the people who are at it or above it, and you then perform an actuarial calculation to work out who is going to be caught up by the rise of the value of the London living wage within the relevant period.
But you have no need to do that, my lord, because you have, in this case, you've just got factual findings that they were paid above the London living wage for unrelated reasons. So no need to do that exercise.
It's not an equal pay case, it's an equal guarantee case.
I'm still...
Yes, and my lord will know. I mean, my answer to that is the one I've given. And
yes, exactly.
Yes.
But that's the problem, I think, is how you conceptualise it.
But so you say that because somebody's going to be at the London living wage and will never fall below it because of your assurance, because they're at then...
No, if it was because of the assurance, my lord, then they would be within the
Then
pool.
you'd be in trouble.
Yes.
Yes.
Yeah.
I'm still...
But why isn't it?
I'm so
Because
sorry, I'm probably not...
The trouble is, we don't actually have any facts about how apart from the ones you referred us to, which are entirely general terms, about how the 160 direct employees are paid. I do see the point, although I don't know quite how you handle it, that if all of them were being paid twice the current level of the London living wage, the existence of a guarantee is entirely theoretical to them. If some of them are only just above the London living wage level, then it's not entirely theoretical, because the London living wage is likely to go up. Inflation is likely to happen. The London living wage, of its nature, I believe, it isn't actually said here anywhere, but I think it is the case that it goes up by CPI as well. So employers are not required to put up wages in accordance with CPI. So those people near the bottom, the guarantee is of real value to them. Not perhaps this year, but next year or the year after. Why isn't that a disadvantage or a detriment or
Well, perhaps one could look at it this way, my lord,
treatment?
that here we are dealing with a time period that has a cut-off in 2019.
Yes.
And rather than saying contingently, well, actually, it might be a benefit to them in future, we are able to say, on the facts found,
Yeah.
it was never needed to be triggered.
Yeah.
We're dealing with the point of principle, though, here, about comparables. And at the moment, I just register the fact that I have simply no idea about how an employment tribunal would go about choosing the pool within your employees. It would be a whole new exercise.
I mean, if it had no evidence to exclude certain people from the pool on the basis that I've set out, my lord, then the answer is simply, well, the pool is the wider one because we got no evidence otherwise. The point that I'm making is they did have evidence otherwise, and they made findings otherwise, and all they needed to do was just to apply the findings that they'd made at paragraph 31.
Yes. Anything more on that point? Which I think we've covered thoroughly.
I don't think so, my lord. And it may be that I should move on to the contract worker point.
What contract worker point?
So section 41.
Low.
Yes.
Yes. So yes, and my lord, the point here is we say, well, the alleged discrimination does not fall as a matter of law within any of the different bits of section 41 concerning discrimination against contract workers. And if the alleged discrimination was to come within any of those provisions, it would be within section 41(1)(a), which concerns discrimination as to the terms on which the principal allows the worker to do the work. But in fact, we say
A or D.
Well, D.
Well,
we
by all means,
say,
take them separately, but I mean, don't,
yes.
you'll have to deal with D.
No,
as well.
I will also deal with
Yeah,
D.
okay.
But the natural home for it is A.
Okay.
And there is no question here of the Royal Parks not allowing the claimants to do work for it on any particular terms. I mean, they would have been entirely content, as my lord has observed earlier, if in fact the claimants had been paid the London living wage. And the Royal Parks did not pay the contract price, which Vinci said would have led to it paying the London living wage. But in my submission, that does not amount to a refusal to allow the claimants to work for the London living wage. The Royal Parks allowed Vinci to pay whatever rate of pay it thought fit. And the use of the verb allow, we say, is a deliberate legislative choice that indicates where the boundary lies between acts for which the principal can be held responsible and acts which are the responsibility of a contract worker's own employer. And that emerges in my submission from Allenby in the Court of Appeal.
If we look at the words of 41(1)(a),
Yes.
it's quite important. As to the term on which the principal allows the worker to do the work. And that may be terms as between the principal and the worker. Does it include terms in the contract between the principal and the contractor? Because the factual position may be that the principal is only prepared to enter into terms which involve the lower rate, not the London living wage. And although Vinci's could have done it, it could be said that the practical circumstances was the terms upon which the principal agreed with Vinci was that the lower rate would be used. And then the question is whether that is within the phrase as to the terms on which the principal allows the worker to do the work, or whether those terms are terms between the principal and the worker. And it doesn't mean contractual terms, it means something more than contractual terms or different from contractual terms. I haven't put that clearly.
I'm slightly surprised that perhaps we're about to take us to some, so I haven't noticed it in the skeletons, any discussion in the long history of this formula about what exactly it means, apart from Allenby, which doesn't really focus on this either.
No, and I've not found anything post Allenby that really addresses that. And yeah, I mean,
do we learn anything by looking at B and C, which don't apply in this case, but might give us some idea of what the terms mean in this, the language means in this context? So there are 4 things, ignore the catch-all at D. There are 3 things you can't do. You can't discriminate as to the terms on which the principal allows the worker to do the work, which is hard to get our head around, and that's what we're worried about. Not allowing the worker to do or continue to do the work. So the contractor provides someone to do the work, and you say, I don't want you to leave the site. And that, very classic case, because this applies to just as much to direct discrimination. It might be easy to test against discrimination. They might say, hang on, you sent a black worker to serve at the tables tonight. We don't want a black worker.
yes.
In the way in which the principal affords a worker access to opportunities of receiving a benefit, facility or service, we don't want a black worker, let me just say, to use the canteen, be allowed to well, I don't know, what other examples are there?
Certain times of day.
Well, yes. I mean, the sort of examples given in Allenby, sort of use of toilet facilities or that sort of.
It's hard. Yes, but it's hard.
Yeah.
Free boating on the Serpentine. I don't know if it includes Hyde Park.
Yes, no, but that's what I mean,
Yes, yes.
That's actually a good example.
Yes.
Or you bring your family in free for a charging facility or something
Yes.
like that. Yeah.
Yes.
Okay. Well, we can think of examples. Does that help us then going back to the terms on which the...
Well, I don't know what the terms mean. Which terms they're talking? It sounds as if it's it sounds as if it's contractual, not.
Well, I wonder. I mean,
or does it simply mean the way in which?
Well, I think
conditions.
I mean, it seems to be that. I mean,
the black workers can only come if they satisfy some different qualification from other workers.
They use one entrance, not another entrance.
Well, yes.
That's not a good example.
Yeah, no, but I think that would fall within it.
So
I see terms as meaning probably something more like a condition applied to them to coming to work, which wouldn't be which applied to someone else. That's why it would be discrimination. Most obviously to what depends whether it's direct or indirect, but it doesn't matter. It doesn't seem to me, whatever it is, it doesn't naturally refer to the terms on which the a contractor is employing them.
No, my lord, and I think that also chimes with the Court of Appeal in Allenby.
Yes.
With respect, I mean, I think that they also had that distinction in mind, and the way that my lord is looking at 41(1)A, I think chimes with 41(B) and C actually.
Yes, A, B, and C are quite limited. They may still be very important in the real world, but they're not intended to go behind the curtain of the terms on which the contractor employs the workers. That's really your point.
Yes.
So we look at Allenby.
Yes. Yes. So, yes, that's tab 8 of the authorities. And I say one finds in all the speeches, Lord Justice Sedley, Mr. Justice Gage and Lord Justice Ward, an emphasis on there being an important distinction between the principle not allowing the claimant to work under certain conditions or not offering her particular benefits where responsibility lies with the principal, and the terms of the claimant's own contract freely agreed with her employer, for which her employer will be responsible. And just picking it up, first of all, in speech of Lord Justice Sedley, the relevant bit is starts at paragraph 35, bottom of page 70. In my judgment, section 9 applies both as between one contract worker and another, and as between one contract worker and an employee, so long as they're working to principle. So far, and without resistance from Mr. Jeans, Miss Gill's argument succeeds. Her problem, however, is to show that in the present case, the principal, that is the college, is discriminating against the applicant when it uses her services through ELS. It is
Sorry,
ELS.
where are you reading from?
I'm so sorry, my
No,
lord.
it's my fault entirely.
Bottom of page 70, I'm just reading paragraph 35.
Thank you, yes.
It is ELS, says Mr. Jeans, against whom the applicant's complaints lie, because it is they alone who set the terms of her employment. This is largely, but not entirely true. There are still some benefits, which Miss Gill would argue are afforded by the college to its employed staff, but not to those brought in through ELS. Professional indemnity insurance, for example, and career development support. Some way from the instances which are usually given, such as an inferior canteen or washroom, but while I share the doubts of Mr. Justice Gage, they are, in my view, capable of ranking under section 9.2 and ought to be considered by the Employment Tribunal. So the clear implication of that reasoning is that where a contract worker's terms are set by their employer, you're not going to have a complaint under section 41.
And indeed, Mr. Khan doesn't really dispute that, but he says these are very exceptional circumstances where, in the real world, the terms are set by the employer, because effectively the economic pressure the employer, the principal applies by saying, well, you can pay whatever you like, but I'm only going to fund you to pay less, which in the real world means they won't pay the London living wage. You say, I'm sure you'd never stoop to this cliche, hard cases make bad law. The fact is, legally, it is still the choice of the contractor what to pay. It may well be that if they're not funded to pay the London living wage, they won't, but they could. They could just take all this to Mr. Khan, so perhaps I shouldn't feed it back to you. But
yes.
But you say if you don't have a bright line there, that's clearly the bright line the Act provides for. And if you don't have a bright line there, what degree of economic quotes reality is necessary before you go behind the contractual curtain?
Yes, and it may be that the sort of two further points to make on that. I mean, one is that it sort of finds its reflection in equal pay law and Allenby, actually, where it's not enough to be a single source, that you ultimately fund the thing and that your funding has an impact upon what people are paid. And the second is that actually, if one doesn't draw the bright line where I say it should be drawn, then it's actually very difficult to see what is sort of particular here, other than what might be said to be a sort of degree of thought crime that that Royal Parks sort of wanted to know what would the cost look like if we paid the London living wage. And I say that can't take that outside the general rule.
And we don't know, I shouldn't say nothing rude about Vinci. It's not exactly absolutes. It's simply what Vinci choose to charge in the two situations. What markup they choose to have, what they think their management costs will be. It's not, presumably these contracts are not formally cost plus contracts.
No. No, we just pay a contractual price. I mean, that's, yeah.
Yes.
Just coming back to, I probably ought to just touch on the other bits of Allenby, my lord. then you have Mr. Justice Gage, whose reasoning starts at paragraph 73 on page 116. Oh, I'm so sorry, I've given you the wrong page. I think I've given an internal, but
Well, the relevant passage starts at para 73 on page 79.
79.
I don't know which bit of it. Well, it's really all there is, isn't it, on this point?
Yes, and then there's Lord Justice Ward, which I
Yes.
probably ought to touch on. I mean, yes. I mean, Mr. Justice Gage, the essential point is the end of paragraph 73. I further agree that where a complaint is made about matters which are essentially contractual, the complaint lies against the employer, not against the principal. I should just say, I mean, you were asking yesterday, my lord, can one find anywhere what are the matters to which he's referring in paragraph 75? And I can't find the Employment Tribunal judgment which would set those out, and they're not really set out anywhere else.
Well, I think we can more or less infer them, and I think this was Mr. Khan's answer from what Lord Justice Sedley said. Professional indemnity insurance and career development support.
Yes, and I think...
And he said that, ooh, those are a bit odd, but he said nevertheless they are, you know, the normal thing we have here is contract workers have to use different loos, but that's it looks as though that's what it was about.
There is a sort of small window into this, but I don't think it shows anything very different. At page 36, we have the EAT
Yes.
in Allenby, which quotes from the ET in Allenby in the indented.
Yes, my lord. It takes one a little bit further, but not very much, I think is... yeah.
Yes, no, that is, I'm grateful to my lord, I haven't picked that up, and it is a bit different. It may well be by the time we got to the Court of Appeal it's been a bit refined, but it's in the same area, isn't it? It's the things which are regarded as benefits of continuous employment, and you could argue about exactly what those are. Yeah.
And then in Lord Justice Ward's speech, 92 is the important point. And Tribunal must ask upon what terms the college allowed her to do her work. College is a principal, it's the principal's conduct which may constitute the unlawful discrimination. If therefore she does not enjoy the rights and benefits set out in the claim, is that because she is not allowed by the college to do her work on those terms? If she's denied those rights and benefits because her contract with the ELS has excluded them, it may still be necessary to inquire whether the college would only allow her to do her work if ELS so stipulated. So that is covering the point not addressed by Lord Justice Sedley and Mr. Justice Gage, that if the principal says to the employer, I insist that the contract must include this term, that that could be a situation where there was genuinely a question of not being allowed to do work upon certain terms.
Let's suppose, not as an example, but you were the nature of the work was that there were work at particular times which attracted higher rates, Saturdays and Sundays, and the in-house workforce can work Saturdays and Sundays and get the double time. Yeah. And if the employer says to the contractor, your workers can only work weekdays. Yeah. That would be an example of the kind of thing that Lord Justice Ward had in mind.
We go back to 41. I know it's crack record 3, the words of the Act. 41, when a principal and a contract worker, terms which the principal allows the worker to do the work. If you go down to 5, 6, and 7, it all becomes a bit clearer. The worker is employed by another person, So you assume the contract of employment is fixed between that other person and the worker. And contract work is where somebody is provided by the principal, somebody provides one of their employers to the principal. So it's assuming that there are two separate contracts, the horizontal contract between the principal and the contractor. There's also a contract of employment between the contractor and the worker, which is being sent off to do the work. And I don't know whether that shows anything as to what the terms on which the principal allows the worker to do the work. Does it probably does mean conditions. It can't mean the terms of the contract of employment per se, because that's outside the scope of what the principal can do. But is it, it's more factual, but I suppose it could be legal if the principal had a contractual term with the contractor saying you mustn't send workers in the circumstances my lord has indicated. That would be covered. So terms is just conditions or circumstances.
Yes, I don't think there's any reason necessarily to sort of read it narrowly. And my lord, I do agree that that would be covered. Yes.
But the assumption is that not the terms in the actual contract, no matter how they arose.
Yeah.
It's only whether they let them onto the site to do the work. And what they can do when they're on the site, but not.
And the assumption, that's right, my lord. I mean, the assumption would be not the terms of the contract worker's contract with their employer, save in the sort of particular circumstances where
it bites on the work they're doing on the site, yes. The terms on which the worker allows the worker to do the work.
Yeah. And I say that applying that test, that the proper conclusion that the Employment Tribunal should have reached was that this was not discrimination of a type that fell within 41(1)(a). And if one looks at the findings of fact, relevant findings of fact start at page 110, paragraph 32. So, first of all, I mean, paragraph 32 just makes clear that it's a public procurement exercise, in fact, carried out at that stage by an executive agency of DCMS, Royal Parks Agency, and on the specification of requirements set out below, and the relevant bit of that specification is clause 4.1.4 over the page on page 111. As part of the completed pricing schedule, contractors had to provide pay rates for each role proposed within the staff structure. So, yes, they're asked to say what they're going to pay. But the rates would be those required to attract, retain and motivate high calibre individuals in the current employment.
And presumably the thinking behind that is, if you're putting something out to tender, you want to be satisfied that in order to get the tender, they're not going to pay absolutely cut price rates, such as you'll get rubbish employees who change every week.
Exactly that, yes.
We want to see how this really works, not that we actually want you to drive the, not as such that we want you to pay the lowest you can get away with.
No, on the contrary, we do.
In a sense, it's the other. Well, it's not so much. Well, I suppose the way the negotiation would go is we would say, look, if you're really only going to pay whatever the minimum wage is, you're not going to get people who will stay. You're not going to get people of any quality, and either you will have to agree to pay more, or you'll have to, or which may or may not require you to increase the price. Or we won't accept your tender because we'll go for someone else who charges more, but we get proper people.
Yes. But coming back to a point that my learned friend began to make yesterday about the about Vinci, quote unquote, wanting to pay the London living wage. I mean, what this was a public procurement exercise where the most economically advantageous tender is the test that's applied. I mean, that's just basic procurement law, and tenderers will inevitably be trying to offer the most competitive price that enables them to get the contract. 4.1.4 is designed to say, well, look, you can't just offer a price that means we get rubbish employees.
You want,
And
it's not either or. You want good people as cheaply as possible.
Yeah. And there's a trade-off. In principle, the more you pay, the longer they'll stay, and the better they'll be.
yes,
That's a highly theoretical level.
Are you covered? Sorry, after you.
If the principal, I'm just trying to work out 41(1)(a), if the principal said we only want you to send people to work who speak English and Welsh, but not any other non-language of the United Kingdom, that would be caught, would it, if it was indirectly discriminatory?
yes, that would be caught, because I mean that would be a question of the terms on which they were allowing the workers to do the work.
Yes, that's
So that would be indirect discrimination favouring
Yes.
bilingual.
in
Yeah.
a sense, it's a more likely example than my more crude example of saying we won't allow black workers onto the site. But you can imagine
You must have 10 years experience. In other words, you know, that might be age discrimination because there may not be a need for it, but you're getting older people rather than younger people.
Yes, because my law says one would then, yes, that is the sort of thing that would need to be objectively justified, and you'd need to say we need bilingual speakers
What's
because
the
of.
difference then between saying, well, you must send us English language people, and don't send us anyone if it's going to put the price up because we're paying the London living wage? You say that's not this case, though.
That's
They
not
haven't
this
actually
case.
prescribed the terms.
Yeah.
It stops short of the prescribing of the terms
Yeah.
of the contract of
Yeah.
employment.
And indeed, I mean, the only reason why the London living wage comes into this at all is because we want to know what the price would look like if in the future we were required to pay it. And so we say, well, what would the price be if you paid the London living wage? And they say, well, it would be X. And we say,
Oh,
well,
is that established on the evidence that was their only concern, or was it at least partly a more
it's, well,
benign concern? We want to do this, but we just got to see whether we can afford it.
it may be both. And I appreciate I'm slightly, I take on board my lord's
You're going
reluctance to
beyond
look
the
at the
findings.
witness evidence, but perhaps I'll just take you to the single paragraph that deals with this, which is Mr. Jarvis, and it's yes, it's page 54. I'm sorry, I'm giving an internal page reference there. It's page 82 and paragraph 30. And the answer is that it was a bit
Yes, I see.
speculative because he wasn't there at the time. But just picking this up in and just continuing with the findings of the tribunal, one then gets paragraph 34, which is the pricing point and how much the overall price would have been included. And then 35, which is a question asked to Vinci, which picks up on the point that my Lord Justice Underhill made. How are you going to, that Royal Parks was concerned about how Vinci was going to motivate its staff and ensure it avoided excessive staff turnover. And Vinci said, well, we've decided to increase the basic hourly rate from national minimum wage because it doesn't reflect true value of employees. We say, how much by? They say, we've increased it to £7 an hour. So just pausing there, I mean, this is all exercise of customary powers of employer by Vinci. It's not the Royal Parks saying you must pay £7 an hour or any other rate.
And then Vinci said, well, how are you going to do that? And
Yeah.
Sorry, TRP did, and Vinci said, well, we can, this is how.
Yes.
Can I just ask one point which I think is irrelevant, but has just been bugging me slightly? There's no obligation, I think, on Vinci to have a dedicated workforce. Vinci, I don't know how they organise themselves, but it may well be that they have more people on their books who are perfectly capable of being Royal Parks toilet attendants. Maybe they're toilet attendants somewhere else, or maybe the skills are such that you can learn them pretty quickly.
Yes.
So that we aren't necessarily, the 60 people we're looking at aren't necessarily a population who only work on this contract. Some may move from one contract to another depending on demands. Sorry, Bill. This week we're going to put you on going to work for the Ministry of Defence toilets in Whitehall, or you see the point I make?
Yes.
Or cleaning in the Royal Courts of Justice. Again, I'm not quite sure where that goes, but it may be, for example, that, take the example of the Ministry of Defence. The Ministry of Defence might actually, on their contract, require you to pay the London living wage, so that when Bill goes and works in Whitehall, he gets slightly more. I don't know how it works. Is there any evidence about that?
I recall there being something about that, and I'm sorry, I was just looking.
Don't worry.
Actually,
Don't worry.
speaking,
Maybe
I
Mr. Khan
can't.
can help it. Nobody has made a point about it, so
Yeah.
it's probably irrelevant. But I was a little puzzled how it will work. I'm quite sure Royal Parks would want generally to have a recognisable, stable workforce, but that doesn't mean necessarily that Vinci has a pool who are the only people who ever do this contract and never do anything else.
No, and the contract is for the service, not the employees.
Quite. That's the point I'm making. Yes.
Yeah.
Anyway, there we are.
So, yes, my lord, I just, and then I think the sort of final piece of the jigsaw on the facts is just paragraph 37, which is the Royal Parks saying that the London living wage pricing is not going to be taken up. Option for paying staff London living wage will not be taken up at that stage. Reserve the right to be revisited at any point during the contract period. So, I mean, that just records the decision. And 39, we see that Vinci paid its staff less than the London living wage. So,
But oddly enough, if they had a term with the contractor that said you must pay your staff the London living wage, but they didn't pay their own in-house staff the London living wage because they couldn't afford it, that would be discrimination because they wouldn't have to rely on Section 41 then. But it is to do with, yes, it is to do with the conditions on which people are allowed to, and they aren't actually prescribing it, short of putting something in the contract saying your terms must include or must not include the following. Anyway, so I'm still struggling on that. Sorry, I beg your pardon.
yes.
Is there anything £60 a day mentioned in paragraph 36?
I'm not aware of there being anything other.
Does it
I
come
might
up
just have a look at Mr. Jarvis's witness statement about that.
I'm alighting on page. No. There's further information about page 22 of the supplementary bundle, which shows that there was background information. It's a quote, I think, from Mr. Khan.
The truth is, we're not going to get to the bottom of this, are we?
No,
that's right.
But in terms of what actually happened, when Vinci said we've taken over this contract, we think that they're being paid too little, we're going to raise it to £7. Back you come and say, how does it fit within £60 a day?
Yes, so £60 a day is the price that they've quoted to us. and we say,
Well, they haven't quoted. What they've quoted the price to you is pretty so much a year, isn't it? These are all internal costings, so that you can see that they're not that it's economically viable.
Yeah.
Past the moment you.
I mean, the information we have at paragraph 34 is that for 5 years, it was just under 6 million, and it would have been just under 6,700,000 if you were willing to pay the under living wage. But apart from that, I'm just not sure where £60 a day comes from. But
Well, presumably there was simply in the no doubt the hundreds of pages of schedules that accompanied the tender. There was a figure saying we have made these assumptions on the basis that we make a 5% profit margin or whatever it is on these costs, and the costs to us for each day for the toilet services will be £60 per employee per day.
that is
like
exactly
that,
what I assume, my lord. But as I say, I mean, there are not. It's to a certain extent guesswork, because there is not findings about that. But that would make obvious sense. That's where it comes from.
thank you.
Well, presumably, I don't know how much of it. Were the full contracts in front of the tribunal? Probably not. Nobody wanted to see them.
Well, I think
But there were large bundles where we've only seen a tiny fraction of what was before the tribunal.
Yes.
Yes, I see.
My lord, so I mean, having gone through those factual findings and having had the discussion with the lordships, I think, I mean, my point is simply that those facts are the exercise of customary power by Vinci as employer, and they don't amount to facts falling within 41(1)(a). And if one looks at how the tribunal dealt with this, the issue was clearly pleaded in the grounds of resistance, and I'll just give you the reference to that. It's paragraphs 38 and 39 at tab 12, and the page is page 185. So there it's pleaded no restriction on what pay or benefits permissible to B to C, and doesn't fall within 41(1)(a). That's the middle of paragraph 38. And the tribunal did not consider the scope of discrimination within 41(1)(a) or the significance of the word allow at all. It just didn't address what subsection of section 41 this fact pattern fell into, or whether it fell into any subsection, because there's nothing in the judgment that deals with that point. So we say that in itself was an error of law.
Well, they dealt with whether they were contract workers at 61, but not whether or not
Yes.
they were in 41(1)(a).
Yes, yes. And we say if the tribunal had considered the application of 41(1)(a), the logical conclusion is there was no discrimination falling within it. But even putting it lower, it certainly wasn't clear. So, we obviously put it higher, but one can't say that the only obvious conclusion to have reached in the tribunal is that it was a 41(1)(a) case. Now, my lord, I think I could just briefly address the counter-arguments put by my learned friend on this, and then I will be done, and I can very briefly...
You haven't said anything about D yet. But
no, and I...
Okay, but do your counter-arguments on A first.
Yes. So, the first of those, and they start at paragraph 15, page 37 of the bundle. The first is to say 41 1A the word allow should be construed.
Sorry, where are we
broadly.
looking at?
So I'm looking at paragraph 15.
Of what page?
Page 37. This is the claimant skeleton.
Oh, sorry, I've got confused with all these.
Yes, so got tab 3
all
of the
A's
core
and
bundle.
B's. Yeah, okay, I have it now. Sorry, 50. Yep. Okay, yeah.
And first of all, what's said is read it in the context of 41(5)(a), which defines the principle as a person who makes work available for an individual. I think the answer to that is that the effect of 41(5) is that the section applies regardless of whether there's a contract between the contract worker and the principal. But that's the entire point of the contract worker provisions. But it doesn't alter the fact that the language of 41(1)(a) requires a focus upon what the principal does or does not allow, and not simply upon whether there's a disparity of terms. Then it said purposive construction. I mean, my learned friend didn't take you to Harrods and Remick yesterday. I think, and I'm not sure it's necessary, therefore, for me to do so, just to say that that was a case where purposive construction and language went together. And what the respondent was asking for was something that was not the language of the subsection.
But anyway, all contracts should be construed, all statutory provisions should be construed purposively, so it doesn't really get anywhere.
Yeah. Then para 15(3), it said that the Employment Tribunal found that the respondent was the effective decision maker and was able to choose the rate at which the claimants were paid. So it was entitled to take a real world view. And that's effectively the reasoning that was adopted by the Employment Appeal Tribunal. And we say that there are two problems with it. The first is that it doesn't approach the issue by reference to the statutory language. 41(1)(a) directs attention at whether respondent has refused to allow contract workers to work on particular terms. And that's not the same issue as whether the respondent is the effective decision maker or any other equivalent phrase that one might apply. And it's the statutory language that shows where the appropriate dividing line is. And the second issue is that the tribunal's conclusion that the respondent was an effective decision maker was not actually, in truth, a finding of primary fact. It was a conclusion. It was a conclusion that was urged upon it by the claimants as a result of the facts it had found, and it accepted that characterization. But in my submission, that was a wrong characterization from the relevant factual findings in the judgment at 32 to 37. You have my point on that. And then finally, it said at 15.4 that in any case, the positive decision to pay below the London living wage translated to the respondent, subjecting them to a clear detriment. And the 3 points that I make in response to that. I mean, the first is we say the respondent didn't subject them to anything. It chose to pay a contract price, which Vinci had said would mean had certain consequences, but that doesn't amount to the Royal Parks itself subjecting the claimants to any detrimental treatment. It was Vinci that did the subjecting. And secondly, the more natural home for this type of complaint is 41(1)(a). And if that doesn't work because the contract worker's terms are not set by or mandated by the principal, it can't be right, we say, that a claim should succeed on the basis of a sweetheart provision in 41(1)(d), because 41(1)(d), any other detriment provision, can't be a means of circumventing restrictions that are designedly built into the statutory language. And thirdly, the analysis in Allenby, we say, would apply to 41.1d, no less than to 41.1a. If you've got a complaint that's about matters that's essentially contractual, that lies against the employer, not against the principal. That's not just a 41.1a complaint. So, for all those reasons, we say if the tribunal had considered it properly, it would have concluded that this wasn't within the section. So, my lord, those are the submissions on the section.
Thank you. I think one thing you said you come back to it and haven't, which is the document which we haven't seen, but which was referred to by Mr. Khan, or am I confusing myself, late this morning about
Yes.
sorry?
Yes, my lord.
No, not the weekend email, no. Another.
Is this the
No, it's the page.
Mr. Khan can remember.
was this the tribunal order? Was it reference to a ET order?
I can't hear what you're saying.
Was it? There was a reference to an employment tribunal order, and
No, that wasn't it either.
No, I think my lord may be thinking of the document referred to at paragraph 75.3 of my
Let's have a
learned
look.
friend's
I think
skeleton.
that rings a bell, but let's have a look.
75.3
I'm
what?
sorry, it's
My,
the stage in the
Mr.
afternoon.
Khan's
My
skeleton.
memory isn't as good as it should be.
Yeah.
What page in the bundle?
And that is page 37L, I think. M. Sorry. Yes, 37M. And it's, yes, so it's a reference across to page 25.
Yes, thank you. That is exactly. Those are closing submissions.
Yes.
Sorry, 18.4 the closing.
Yes.
That is the point. And you said, and I put that to you an hour or two ago, and you said,
And I'm sorry, I said I'd come back to you.
You said you come back to it,
Yes.
and you didn't actually have the meaning that Mr. Khan suggested, and which
Yes, and I think it's 18.5, isn't it? And I say that doesn't have.
Yes, can we just find where it was actually referred to? But that isn't where Mr. Khan referred to it. I think he referred to it in his closing submissions.
Yes, so that's supplemental bundle page 25 at 18.5.
Thank you very much indeed. Yes, Claire
Yes.
Ward's advice to the board. It is 18.5, as you rightly say. TRP's own staff are all paid above LLW. In recent years, we've included the minimum absolute value in our CPI pay awards, which means that those pay awards receive an increment above CPI and their pay remains above LLW. Now, I agree, I think I slightly mischaracterised that to you, but the underlying point is still the same, that for the lowest paid staff, what apparently is happening here is Royal Parks are saying we had to give them a bit more than we otherwise would, or at any rate more than CPI, in order to make sure they don't dip below the LLW. So the nice clean position you put to us that none of these people were, as it were, in the LLW target zone appears to be contradicted by that little extract.
Yes, I mean, I think my answer to that is that what the extract doesn't say is that pay awards were made in order to ensure that staff were not paid below the London living wage.
Isn't
Now,
that a clear inference?
I don't think I could. I am, in fact, instructed that's not the case, but I'm not going to.
I see, okay.
You know, but
Well, I think what you
it's-
probably can say, which is not point I've made already, I mean, this looks damaging to you on this particular point, may not matter overall, but there's no finding about it. It's just an extract from a submission from a document of which we haven't seen the whole. We don't know whether Claire Ward gave evidence or was cross-examined. Do we know any of that? Sorry? She did.
She didn't.
All right, but never mind. We don't know whether anyone was cross-examined about this, or without findings, it would be very unwise for us to treat
I mean, I
this as a
do come
point in
back
its
to the
own
point
right.
that the findings are those at paragraph 31 of the Employment Tribunal's judgment. And those are clear, we say.
Very well.
My lord, I think the only other point is actually point subparagraph 3 of the respondent's notice, which is that the tribunal erred in concluding that the Royal Parks had applied the relevant PCBs to claimants. But I acknowledge that that is, it's effectively a mirror image of the point that I'd be making about section 41. So I don't think, you know, I mean, it stands or falls with that. So I'm not going to address you separately on it.
Unless my lords have
You were going to give us the email and you were going to tell us if there's any significance to the 19th of December 2019 date, but if you haven't got them, don't worry.
That's Mr. Khan is doing that. He sounds like he's got something to give us.
Can I just turn back to me? Thank you very much.
Thank you. Any reply, Mr. Khan?
Thank you, my lord. Could I just be clear? I want to make sure that you have all the documents which you show the documents which you asked.
Can you speak up a little?
Could I just ensure that I'm clear on the further documents which you asked for before lunchtime? So
Only ones I observed that we didn't have the overnight email. In fact, I think I did ask for that, the over weekend email.
yeah,
Just had that come in.
I noted but didn't ask for the document we've just been discussing with Mr. Milford, that was incomplete, so I didn't ask for that. And I think lastly there was a tribunal order which led to the grant of the further particulars.
yes. So we have.
This is a disclosure.
That's not disclosure.
Yes.
Okay.
Are they better sent in?
Sorry?
Are they better sent in an
Okay.
orderly way? Better received now?
Well, okay, probably. Well, if you've got them here, hand them up. But if you haven't, send them to us later.
Yes. So we have the tribunal order
Well, why don't you pass that up?
and the email.
You got that as well? Good.
Have it
Could-
on email. We're going to forward it to.
You haven't got a printout?
No.
Okay,
Just
well,
received.
it doesn't matter. Could you send us, after the hearing, soft copies of both the email, which, as you say, will be in soft copy, and the order, because some of us work electronically and some of us work in hard copy.
Yes.
Thank you.
Oh, right. So hang on. We've got 3 docs, but they're not all the same. I've got 2 copies of an order to disclose documents
No, that's not the one.
and 1 copy of an order on the preliminary hearing case management.
No, it's
That's the order to disclose. We passed 2 copies of that.
asked for a copy of the order.
Look, this is all taking too long. Why don't you just send them to us later, unless there's points you want to make on them.
Okay.
Just to be clear, the
I'm
second
going to give those back.
is Claire Wadd's advice to the board. 5th of September 2019.
If my lord wants to see that, then we
No,
should.
that was the second one. you
Yes,
referred.
I alluded to the fact we didn't have it. I don't think I expressly asked to have it.
Right. Okay.
So, I speaking for myself, I don't really want to have it because I think we have to ask questions about it.
Okay. So we should.
This, my lords may want something else, in which case they should say they will say so. But I want the order which directed the further and better particulars,
Yes.
and I want the so-called Friday night email.
Yes.
I don't want anything else.
Right. Okay.
Okay, those two documents.
Thank you. Right. Now, reply.
My lords, there are a number of points, and the first one is I think it's important in this case to separate out two stages, very related but nevertheless distinct stages. One is the formulation of a PCP, and the second is the application of a PCP. And I think it may have been said, or that the pool automatically flows from the PCP once you've identified a PCP. I would put it slightly different. Once you've identified the application of the PCP, the relevant pool comes into form. My lords, our case at first instance was that the PCP, well, I won't go over yesterday's ground, but the PCP is how you interpret it on the pleadings. What I say, looking at it cold, is that the words themselves leave open whether the issue of whether it could be applied to contractors in addition to Vinci contractors, even though our focus in the pleading was very much on Vinci contractors. In closing before the Employment Tribunal, we were not reformulating the PCP. We were saying that the PCP on the evidence had been applied to the Vinci contractors, and there was no evidence of it having been applied to others. And the reason why I address you on this point is because I need to take you, if I may, to the EAT's reasons core bundle tab 7. And it's page 87. And paragraph 81 of my submission should be read with that distinction in mind. What we were arguing at first instance in closing was not a reformulation of the PCP. We were saying that the evidence disclosed relating to the application of the PCP pointed only to Vinci contractors being in the pool. At paragraph 84, which is over the page, if I could pick it up at 4 lines into paragraph 84, with the EAT's sentence, that was illogical and amounted to an error of law, as whichever way it was defined, the PCP complained of by the claimants plainly required an assessment of its impact across all those directly and indirectly engaged. I say the bit missing here, with great respect from Mr. Justice Eadie's judgment, is that she says once you have the PCP, you automatically have the pool, and she skips over the stage in the analysis, which is the application. My lords, my learned friend said that the Nelson decision was authority for the proposition that the claimant bears the burden of proof in an indirect discrimination claim. No issue with that. What I say the Nelson decision is not authority for is to say the claimant bears the burden of proof in showing that the respondent applied the PCP additionally to others. If the respondent in any given case wants to make out that other people should be in the pool because it applied the PCP to them, I say, as I said this morning, the usual principle of he who pleads must prove applies.
This was not a case in which there was any mystery about the identity of the other outsourced workers. There were various categories, the other 6 categories.
Yes.
And they were all within a relatively defined geographical setting within the parks estate. I suppose there could be cases where one was dealing with a much larger employer and outsourcer, in which that would not be the case. In other words, there would be, we have an image in our mind where maybe the canteen worker, the cleaner, the gardener sort of are on nodding terms with each other because they're working near to each other. But the principle has to operate in a wider context also, where there may be people in different geographical locations far distant from each other who have the same outsourced employer.
My lord, you're quite right. As to the facts of this case, without wishing to give evidence on appeal, the Employment Tribunal heard evidence of the typical daily role which park workers had, which was centred around the public toilets spread across various parts.
But I was more thinking about the point of principle here, not to do with the evidence in this case, but that it may be that there would be other cases in which you literally, as an outsourced worker in one neck of the woods, you wouldn't have the faintest idea what your employer, if it was a very large employer, was doing in other places.
My lord, yes.
At least without getting orders.
That's why the pleading point is perhaps not as technical as it seems, because if you had unquestionably pleaded a PCP applying only to you, and therefore a pool only of you, and you I appreciate say that is the effect of what you're doing, but suppose, but if you've done a good deal, suppose we're against you on that. Start again. If that is what you had explicitly done, then the respondents would have had to say, well, I don't care about the ethnic minority breakdown in that limited number. That's not representative of everyone to whom we applied this policy. And then, speaking for myself, I agree, and chiming on what my lord says, they've got to say, you only see how this policy applies to you, but you're only a tiny group. Actually, it applies to a much wider group who don't have the same ethnic breakdown as your group. And then, again, speaking for myself, I would have thought that's something you do have, the respondent does have to plead and prove. The difficulty, if we are against you on the first point, is that we weren't in that area. You had already pleaded the correct group, you just didn't go ahead and prove it. Sorry, that's just me setting out in case you want to comment.
My lord, we pleaded the PCP in a way which left it open whether caterers, wherever they might work or whoever they may be, and might, in principle, come within the PCP if it had been applied to them.
Yeah.
So, But there's a difference between where the emphasis or the focus of our pleaded case was, and then what it left open in principle.
Okay. And that's how that analysis plugs into your first point. Yes,
Yes.
thank you.
So the claimants, I think, as you can probably imagine, have quite limited contact even amongst themselves, let alone with other.
Yes, I don't think my Lord's point depended on that. I mean, I'm sure. I think that if it, actually we're not concerned with what they think, but what their advisors knew, their union knew. We don't know much about that either. We don't know to what extent UVW is organised in other parts of the parks workforce. It may or may not be. We just don't know. Which all comes back to we must read the pleadings.
My Lord, my learned friend, I think one of his themes is, well, it's incumbent on the claimants to ask for disclosure. That's one way of looking at it. The other way of looking at it is who has a duty to disclose. What about when one party offers to disclose documents and then does something of a U-turn? When one party mentions in their pleading in a footnote that they will disclose documents and then doesn't. But then a friend also said, well, you can draw a parallel with equal pay cases, and if this was brought as an equal pay case, changing the facts slightly, the claim would not have got very far. My Lord, this is a case where the elements, once they were proved, simply put a duty on the respondent to provide a justification. And as Lady Hill says in Aesop, there is no shame or stigma in having to get to that stage for a respondent. The point about material differences and how, I think my learned friend puts it today on a second appeal, you should have carved out from any pool people who were comfortably above the LLW, is a new point. We mentioned this in our skeleton, paragraph 75. And my lords, you'll be familiar with the decision, the EAT in Rance.
I'm not.
Okay, if I may then very briefly.
Well, just tell us what the principle is. Maybe the principle is straightforward. What's the point?
The principle is if you want to argue a new point on appeal, you have to persuade the appellate body to exercise its discretion.
Yes. Well,
and then there are factors relevant to that discretion, and the one we say is important here is, can the new point be argued without further factual inquiry?
Yes. Which is the new point you're saying is being argued?
Which I think this is my learned friend's third material difference.
Namely? I get confused about numbers, but I can recognise the difference.
Different bodies set pay.
No,
No.
I beg your pardon, my lord. It's the one. It's reason 2C, and it's that the respondents' direct employees were always paid above the London living wage. I think to use my Lord Justice Underhill's phrase, would not therefore have been in the target zone.
You say that's a new point.
Yes, my lord.
I thought the evidence was that everybody was, bar they thought there was a problem with one and they checked him out and he was above the line as well. Or have I forgotten the evidence?
Yes, that's the evidence and the finding. But in terms of what was argued to be material difference, my lord, the reference there is the grounds of resistance.
What are the new evidence as opposed to the new point? You said
New
if it's
point,
a new
yeah.
point, we
Yeah.
must grant our exercise our discretion. And one of the factors relevant to whether to exercise it is whether new evidence would be required.
Yes.
But I thought we had all the evidence.
Well, we have the evidence in relation to a particular,
We're not just evidence, we have the findings.
yes, in relation to one particular employee.
No, why is the finding that, and I maybe misquote slightly, but there's a general finding that the direct employees were always paid more than the London living wage. Why doesn't that preclude any worry about further evidence being needed because facts have been found?
My lord, it's the point we make in the call bundle, page 37N.
Paragraph 74.
My lord, yes, 74 and 75.
Sorry, 37A.
M.
Yeah, sorry. Yeah, thank you.
75.1, we say how the cross-examination would have perhaps explored this point in more depth with their only witness. And 75,
No, fair enough.
75 too, we talk about.
Yeah.
And I was finally on the issues of material scope, section 41, 1A and,
Yes.
and D. Well, I say in 41, 1A, the word terms needs to be construed broadly. It can include contractual terms, but it's not limited to contractual terms. And it may even, for example, include terms in the horizontal contract. If there is a contract between principal and contractor, which says, as one of its terms, the hourly rate for contract workers will be X.
Yeah.
I also say that, I won't take you to it again, but the judgment of Lord Justice Sedley in Allen B, especially paragraph 34, talks about how it would be remarkable if legislation which treats the principal's own contracted labour as employees could then be got around if you simply outsourced people and put them on inferior terms.
Well, it might be thought to be remarkable the other way if outsourcing had the result, if even though you have outsourced, you are in practice obliged to pay or to require your contractor to pay the same as you have paid to your existing workforce. Especially when we know that that is not the position in ordinary equal pay law.
Well, that's why I say, and I think this is how I opened yesterday, the facts of this case are particularly stark.
Yeah. No, I see that, and that is indeed what you said, and we'll have to think very carefully about that. But I think you were straying into a rather general proposition about which would it, if it were right, apply outside the facts of this particular case. The strength of your case is that in the real world, Royal Parks produced the result that Vinci paid less than they would have been prepared to pay if they'd been funded.
Yes, it is not simply the outcome which was produced. It was, I could borrow my lord's phrase from yesterday, it was the hovering, or the focus hovering. It's the manner in which the result was.
Yeah, no, I see that. Yes.
And similarly, with 41(1)(d), my learned friend's point focuses on the word subject to a detriment. And I say subject, my submission is really a question of fact and the evaluation of fact, which this employment tribunal was entitled to make, and there is this is not a perversity challenge.
But Mr. Milford says they didn't decide the scope of 41A or D. They decided whether they were contract workers. I forget which paragraph, but they didn't actually go on to decide. And if they satisfy that bit, 41(5), do they fall into 41(1)A or D? So he says it's not a perversity challenge; it's a failure to deal with it challenge. I suppose.
Yeah, I readily accept they don't cite either subsection. But I say the facts which they find and the factual conclusions they make are more than capable of fitting into either section.
Yes.
My lords, unless there was anything else which I could help you with.
No. Well, we are genuinely grateful to both counsel for clear and thought-provoking submissions. And we're sure that those would have been informed by the help they've had from those behind them. We will take time to consider our decision. In due course, judgments will be circulated in draft for the primary purpose of giving the parties an opportunity beforehand to agree the terms of the necessary consequential orders, and if they can't agree, providing brief written submissions so that we can resolve any matter of that kind before the time of hand down. There's also the secondary reason of, but important, of correcting any typographical or other minor factual errors. Council will by now be very familiar with the stringent rules applying to the purposes for which draft judgments can be used. If you're in any doubt, read the Counsel General for Wales case. And thank you very much.
Half 4.